The Centre for Public Legal Education Alberta, CPLE, is a non-profit organization with the goal of making the law understandable for Albertans. CPLE provides legal information and education to the public. Only lawyers can provide legal advice. Look for our contact information at the end of this video. Enjoy!
We get a lot of questions about how to plan for the future. We're not talking about saving for retirement. Rather, we're talking about having legal plans. Have you thought about who will look after your personal and financial affairs when you no longer have the ability to do so? Have you thought about who will deal with your estate when you pass away? And beyond just thinking about it, are your plans set out in the appropriate legal documents? This video describes 3 legal documents every adult in Alberta should have: a personal directive, an enduring power of attorney, and a will. In a personal directive document, you appoint a decision maker called an agent. Your agent makes personal decisions for you while you are still alive, but do not have the ability to make those decisions for yourself. An enduring power of attorney is similar to a personal directive in that you appoint a decision maker to make decisions while you are still alive. Under an enduring power of attorney, however, your attorney makes your financial decisions. The last document is a will. It is different from a personal directive and enduring power of attorney because it only comes into play once you pass away. Your will does 2 things. First, it appoints a person to manage your estate. This person is called your personal representative. They used to be called an executor or executrix. Second, your personal representative must follow the instructions in your will about how you want your estate dealt with, such as giving your property to certain people. You must have full mental capacity to make and sign these legal documents. Mental capacity is defined in Alberta laws as the ability to understand information related to making decisions and the ability to understand the consequences of those decisions. For example, to make a will, you must understand what property you own and who will get it when you pass away. You also must understand what will happen if you give one person your property over another person. For more information about mental capacity, watch our video called Mental Capacity in Alberta. Now we're going to look a bit closer at each of these 3 documents. A personal directive is a legal document. It is sometimes called a living will. It must be in writing, you must sign it in front of a witness, and that person must also sign it. The decision maker you appoint in the document is called an agent. Your agent makes decisions for you while you are still alive. They can only make decisions about personal, non-financial things. For example, your agent might decide what healthcare or medical treatments you receive, where you will live, and what activities you will participate in. The law in Alberta says your personal directive only comes into effect when you do not have mental capacity to make these decisions. Your personal directive can say who decides when you no longer have mental capacity. Most people say that 1 or 2 doctors should make this decision. A declaration of incapacity is a form that says you lack mental capacity. Once this form is completed, your agent can make personal decisions for you. You and your agent must keep the original personal directives documents. However, if you have a personal directive, you can register the name and contact info of your agent with Alberta's Personal Directive Registry. That way, a doctor or other medical professional can contact your agent if a decision needs to be made for you. An enduring power of attorney is also a legal document. It must be in writing, you must sign it in front of a witness, and that person must also sign it. The decision maker you appoint in this document is called an attorney. Your attorney makes financial decisions for you while you are still alive. These decisions could be about your house, your money, your taxes, and much more. Unlike a personal directive, which only comes into effect when you no longer have mental capacity, your enduring power of attorney can come into effect in different ways. You can say that it comes into effect when you lose mental capacity, and you can say who decides that you no longer have mental capacity. Or you may want your enduring power of attorney to come into effect on some other date or event, maybe when it is signed or when you reach a certain age. It is very important that your enduring power of attorney says that it continues to be valid even if you lose mental capacity after you make it, or that it takes effect when you lose mental capacity. This distinguishes an enduring power of attorney from a general power of attorney. General powers of attorney are legal documents that you can use to appoint someone to look after all or some of your finances for a certain period of time. For example, you might give someone power of attorney to pay your bills if you plan to be out of the country for a month. However, general powers of attorney become invalid as soon as you lose mental capacity. This is why an enduring power of attorney is so important. Finally, a will is a legal statement of what you want to happen to your estate after your death. In your will, you usually appoint a personal representative, which is the person who has the legal responsibility of dealing with your estate and following the instructions you leave in the will. You also usually name beneficiaries of your estate. These are the people you want your property to go to. You can also name guardians if you have children who are under 18, and you can include your funeral wishes, such as whether you want to be buried or cremated. Your personal representative only has authority to deal with your estate. Your estate is the property you own at the time of your death, including land and possessions. Your personal representative must distribute your estate according to the instructions in your will. But some property you have is not included in your estate. Your estate does not include two kinds of property. First, your estate does not include any property that you own in joint tenancy with one or more other people. Property commonly held in joint tenancy includes your house or land and bank accounts. When you die, the other joint tenants automatically become the owners of the property. Second, your estate also does not include property with designated beneficiaries. Examples are investment accounts, insurance policies, or pension plans. When you sign up for these things, you can usually name a beneficiary. The beneficiary you name can claim the value of the asset from the plan administrator when you pass away. There are 3 different types of wills you can make. A formal will is a will that is in writing, either handwriting or typed up. You are called the testator. You must sign the will in the presence of 2 witnesses. These 2 witnesses then must sign the will in your presence and in the presence of each other. This is the most common type of will. A holograph will is a will that is entirely in your writing. You must sign the will, but nobody has to witness it. Holograph wills are valid in Alberta, but they are not valid in every province or territory across Canada. If you are on active service with the Canadian Forces, you can make a military will. It is similar to a holograph will and does not have to be witnessed. So why do you need these documents? Sometimes people think that their spouse or partner or other family member will be able to make a decision for them if need be. But this is not true. No one has a legal right to make decisions for you unless you have these legal documents in place or unless there is a court order giving someone authority. Getting a court order can be time-consuming and expensive. You can save everyone the trouble by getting these documents prepared now. We also hear people say that they don't need them because they are young or because they don't have any property. But none of us knows our own fate. A bus could hit you tomorrow, even if you are young. These documents provide protection in case of illness or an accident. They also provide certainty for your family and friends in stressful situations and allow you to have more control over who is making decisions for you. If you don't have these documents in place, then your family or friends will have to apply to the court for permission to make decisions for you. You can make these documents in several different ways. There are do-it-yourself kits available at registries or online. Or you can make your own. Or you can hire or retain a lawyer to prepare these documents. Often, lawyers will charge a flat fee to prepare all 3 documents together, either just for you or for you and your partner or spouse. There is also a fillable form you can use to make a personal directive. This form is available online from Alberta's Office of the Public Guardian and Trustee. Make sure the form references Alberta to be sure you are using the right one. So what's next? Where should you keep your documents? In a safe spot, such as a safe or filing cabinet at home, or in a safety deposit box. You can also give copies to your appointed decision makers. You should only have one original of your will. However, you may have several originals of your personal directive and enduring power of attorney that you can give to your agents and attorneys. When should you review your documents? Take a look at them every few years to make sure they still reflect your wishes. You should also review them when relationships change in your life. If you get married, start a new relationship, or separate from your partner or spouse, or if a family member dies. You should also review if your appointed decision maker dies or tells you they no longer want to act for you. You cannot make changes on the document itself. You can change your documents by making a new document and revoking or canceling the old one. Or you can make a document that sets out your changes to the previous one. In this case, both documents would be valid. For example, a document that changes part of a will is called a codicil. These documents have to be made in the same way as the original, such as being signed and witnessed. There are many resources available that explain more about these documents and how to prepare them. The Centre for Public Legal Education Alberta has created many resources to help you understand more about planning for the future. All of our resources are available for free online or in print. Visit our website for more information.
Thank you for watching this video from the Centre for Public Legal Education Alberta. We endeavored to make the law understandable for Albertans. You can find CPLE's resources on our website, cple.ca, or reach us via email at info@cple.ca, or simply by phone at 780-451-8764. Until next time.